So think back to the first presentation you heard today from John Barton concerning when companies are supposed to be preserving electronically stored information and how they can get into trouble with sanctions for not doing so. Next up, you're going to hear about the fun flip side of that, where you get to discover and uncover the electronically stored information of your opponent and use it productively. We're going to hear from Scott Etish from Gibbons on that very topic and how we can discover your opponent's tweets and Snapchats and use them to your own advantage. Please help me welcome Scott Etish.
Thank you, Nikki. And I was going to refer back to Jonathan Barton's discussion, which was great this morning. And the topic may be a little bit misleading because it really doesn't need to be your next nightmare. If you act appropriately and you follow the litigation hold requirements and you have a good idea of your information governance systems, it really doesn't need to be your nightmare. I think you can really use it as a very strong tool in your discovery arsenal because it's extremely powerful, but it's something that you need to be patient with. So we're talking about forensic imaging, and I'm going to specifically focus on forensic imaging with respect to mobile devices because there's been case law out with respect to forensic imaging on computers and portable hard drives, and I'm going to touch upon those because the cases are rooted in those early cases, but I want to try to focus a little more on mobile devices. So first I'm going to talk though about the information age in general, how we communicate, how this is only going to get worse over time in light of the way that we communicate. I'm going to highlight a couple of the key cases in the area, and then I'm going to talk about some best practices and some key takeaway points. At the outset, I always like to stress the importance of counseling your clients, counseling your employees on smart communication practices. Put down the electronic devices. Be smart about using your computers. Be smart about using your phones. And we've all lived through it, and technology can be extremely convenient. It makes everyday life, professional life, it makes a lot of things very easy. But with that convenience comes a whole host of risks that are very problematic, especially when we're dealing with sensitive information. So go back to the old days of call your colleague and don't leave a detailed voice message. Just call them and ask you to call them back and have that in-person conversation before you put down everything in electronic communication. In the early days, and Jonathan Barton talked in about 2006 when there were the first amendments to the federal rules of civil procedure, we used to talk about email. Email was this great smoking gun, and we'd say, you can't imagine the things that people say in email. They'd never say these things in letters. They'd never dream of making these very concise and dropping their guard and saying things in emails. And now it's become email seems to be the formal mode of communication, and you have all these other modes of communication that are now the less formal means of communications, and those are the ones we're talking about as far as the smoking gun now. But you obviously still need to keep email in your discovery approach, but there's a lot of other stuff out there. So in getting ready for the presentation today, I was thinking about different videos I can bring, maybe a montage showing a CSI-esque with a bunch of different types of communications, and instead I just came here with a couple of cartoons. So it's a little bit ironic that we're here talking about forensic imaging and technology, but here we are going back to some cartoons. So this is the evolution of communication. We start with the first written word, movable type, to mass publication, and then we're starting to go back down the hill here with email and Twitter, and only using 140 characters on Twitter, and back to arguably caveman status. So I think that it molds back into this discussion of smart communication and being aware of not letting your guard down and being smart about your use of electronic devices. And as I said earlier, this trend is only going to get worse. And I think with the prevalence of electronic devices and bring your own device policies in the workplace and just the way we communicate in general, You read all these articles about millennials and the struggles to have in-person conversations. I mean, at times it can feel like you get a text message from somebody, you call them back, or you ask for an in-person conversation, and it seems like you're putting them out. So we have to change that, because with all of these electronic communications, the information trail is staggering. We leave more and more information out there, and it's only going to come back to bite us in litigation. So this next one is another example of the difficulties in having an in-person conversation. So this is Kayla, and she's looking dumbfounded at her teacher as her teacher says, please tell your classmates what you did during the summer, because we don't always follow you on Twitter. So there's just this over-reliance on social media and different electronic communications to make your point. It's clear now that we are in a new frontier of ESI, and in focusing on the different types of data that we create with our just simply our mobile devices, it's incredible. Between text and voicemail messages, your call history, browser and internet search history, photographs, video and video recording. You have GPS data, cellular and Wi-Fi location history, maps and the navigation history. I mean, just think about how much is out there by just using your phone every day and applying it to litigations. And we've seen this a lot in the personal injury context. We've seen a lot of cases also addressing social media and the discoverability of social media in the personal injury context, but you can also, I've used it in cases involving non-competes, breach of restrictive covenants, and theft of trade secrets, where you're dealing with an employee and what type of information they're downloading on their way out. You'll see it with laptops, where we'll be, if you're on the receiving end of one of these lawsuits, the filing papers may be accompanied by a report from a forensic expert, and the report may have indications as to every single time this individual plugged in a USB device, what time they did it, how long it was connected, and what they were doing on their way out. There may be indications of every single website that this person visited. Perhaps they're plotting to move to a competitor in the Midwest from the East Coast, and they're looking at Trulia, and they're trying to figure out real estate and where to move, and you get this map of an individual's activities on the way out, and it can be incredibly helpful on one end and incredibly difficult to defend on the other. And you can see how the information such as that's left behind in your cell phone, if you're visiting with a competitor and maybe you're taking pictures of a product that you're the employer that you're leaving, you're taking pictures of a product, you're taking pictures of videos, or you're going to meet with the new competitor, and there's a stream of text messages. There's so much out there, so you really need to make sure that you pay attention to this and add it to your discovery arsenal. So how do we go after this in litigation? So Federal Rule of Procedure 34 permits a party to inspect, copy, test, or sample any designated documents or electronically stored information. And the 2015 amendments, which Jonathan Barton talked about earlier, changed this a little bit. They add this concept of proportionality, so that's going to make it even harder. And I'll take a step back. When I talk about forensic imaging, this is an extraordinary request. This is your exceptional circumstances, and it's not easy. And it wasn't easy under the previous set of rules, the pre-2015 amendments, and it's going to be harder in wake of these previous amendments. So under the new rule, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefits. So you've got a couple more hurdles in there that allow for a good defense if you're trying to defend against this, but some more hurdles that you have to get over if you're the requesting party and you're seeking this information. So in thinking about why this information is so important, I've got two more cartoons to really exemplify why we need to do this. And I'll suggest that it's important because people can be pretty foolish. They do very silly things, and we're not just talking about personal injury plaintiffs that are trying to game the system. We're talking about graduates from the Midvale School for the Gifted. We're talking about executives, and we're talking about lawyers, and that take these actions after litigation holds are sent out that boggle your mind, frankly. There's stories about executives lighting hard drives on fire after an attorney says, you need to preserve this. There's stories about lawyers scrubbing hard drives, about attorneys telling their clients after litigation has commenced to clean up your Facebook account. Things that you clearly cannot do. You can't tell a party to go out and spoliate. So we very smart people can do some foolish things, and it used to be in the form of perhaps shredding letters, shredding documents. And now you have all these different things, and technology advances, but people stay the same. You've got this flying car, and this man commuting to work, and he's got his coffee mug on top of his flying vehicle, just as if it's a car. So you have all these different types of, all these different, great technology and platforms to communicate, but it doesn't matter because people are doing the very same thing. And as litigators, we love to follow when they let their guard down, and follow that trail, because many times they are going to let their guard down, and you're going to have some great material to go after. And make sure if you're counseling these parties to continue to counsel your employees and clients is to be smart about this, because it's an ever-evolving area. So in talking about the cases, and I mentioned earlier, it's an exceptional circumstance where courts are going to require a party to turn over electronic devices, but it's not unprecedented. There are a number of cases that have allowed it, and typically the requesting party is going to have to show that they were unable to receive the information through your traditional means of discovery. And they're going to be more likely to be successful when you can demonstrate that a party has failed to fulfill their discovery obligation. So you're already going in and saying to the court, this party has spoliated, they haven't complied with their discovery requirements, so they're already one foot in the grave, so to speak. So Genworth is a case out of the District of Connecticut, and this is plaintiff presented evidence that a defendant had used his personal computer and email address to access and transmit proprietary information. And one of the major issues here was that the defendant admitted that he spoliated evidence, despite the fact that counsel instructed him not to do so. So the court found that this was enough for forensic imaging. Typically, you don't have a defendant saying, "You're right, I spoliated, I admit it." So this is certainly the simple example, but it exemplifies that when you have a party and when you can go in and demonstrate that a party has failed to fulfill their discovery obligations, that you're going to be in a better situation to have a court approve your request for a forensic imaging. There's a well-established body of law following this, a Merriwood case, which is out of the Eastern District of Missouri in 2006. And this stands for the concept that forensic imaging many times will be appropriate where the causes of action are directly related to the electronic devices in issue. For instance, you have a party that is downloading information or sending information from a computer to their own personal email address, and they're attaching that confidential information, or they're downloading information from their company onto a USB device. So you're really dealing with this specific type of information that's directly related to the cause of action. So you have all these questions like, what happened to the electronic files sent from one party's email system to the other? Where were the files sent? After they were sent, what did they do? Did they access them? Did the party modify them? Were they altered at all? Were there attempts to scrub the documents or delete them? Were the documents accessed on another computer and then uploaded or copied onto another device? So those situations where the mobile devices or the electronic devices are directly related to the cause of action, you're going to have a lot more success in arguing, because you're going to be entitled, and you'd argue to the court that we should be able to investigate how and whether the party handled this information, what they did with it, and where it was accessed. In addition, and this issue comes up a lot as far as you seeking information and you don't get what you're looking for, and you're sort of dealing with this going blind or moving in the dark because you've asked for emails, you've asked for ESI, and you get back nothing. And you know that you should, but how can you go to the court without any specificity? So the number of the cases involving requests for imaging highlight the need to set forth specificity, and it's difficult, and it's a real challenge. For instance, in the Bailey versus Scoutwork case, it's a whistleblower breach of contract case. There was a dispute over the discoverability of several text messages and voice messages. Defendant did not produce the text messages and asserted that it could not recover them, but it later came out that defendant had an expert review the mobile device in issue, and plaintiff said, well, hold on, if you have an expert reviewing these mobile devices, why can't I have the same opportunity? And through discovery, they were able to hone in and identify a series of different messages. So in their application to the court, they said these 5 text messages and these voice messages, these are the ones we want. We know that the defendant already had an expert review the mobile device, so we should be able to go in there also. And the court recognized that this was sufficient and acknowledged the specificity of the request. This situation is in stark contrast to the situation I talked about earlier, where you really don't know what happened, and it's based on this mere suspicion. So you see a lot of these cases addressing language such as mere suspicion is not enough. I just think that there's more out there. So that's really the challenge in going forward. And the practice tips here, I think the most important one is taking your time and not going into a court right away, and taking the time to develop your discovery record and make sure that you're able to develop the theme that the party has failed to comply with their discovery obligations. Is there spoliation out there? Is there a pattern of spoliation? And are there other means of obtaining this information? Because if you go to the court and say, I can't get this information any other way, and the party has been repeatedly spoliating, you're going to be in a lot better situation. And obviously, be specific, but take your time, develop the discovery record, take depositions, serve interrogatories, take depositions of a custodian of records, and really hammer down what they were doing or what they were not doing before you seek an order requiring a party to hand over mobile devices. I'm sure a lot of you are thinking about potential privacy concerns here. You're saying this is my mobile device, this is my personal computer, what about all my personal information? And that information really hasn't gone or that argument or concern hasn't really gained too much traction with the courts, because the courts can put into place a number of procedures where you have a court-appointed expert, and the expert will oversee the process, and maybe counsel for the responding party can review the information, and there can privilege log can be prepared before that information is disclosed. Because if you're going into a court and it's already been established that you failed to fulfill your discovery obligations, your privacy concern is not going to be as big a concern to the court as if you had fulfilled your discovery obligations. It's really an ever-evolving area of law. We're seeing rapid developments. I just saw a case the other day, actually yesterday, in preparing for this presentation, where a court required a party to provide access to their Fitbit information. So, you have all these new applications, and you have all of these electronic devices that are fun, that make your life easier, but with them come a great deal of risks, and the information trail continues to be developed, and make sure you pay attention to it. So, thank you very much.